Okay, people, so you want to bring in a recording that you've made of your spouse or your significant other in relation to your family law case. Well, bad news is that you probably can't. Confidential communications or private communications are protected, and if you record them without the other party's consent, or another narrow exception that I'll get to in a minute, there are criminal penalties as well as civil penalties for trying to bring that into court. So you need to definitely speak to an attorney before you want to try to bring in a recording. So how do you get these recordings into court? Well, like I said, the other party has to consent, since California is a two-party consent state. The other exception is if the other party is threatening you, and that is in a domestic violence context, but the recording has to be an actual threat. You can't be baiting the person into threatening you or things like that. They have to be threatening you outright, and that's a very narrow exception. Judges do not like bringing in recordings, okay, that in which the other side is not on notice of. So how do we get around it? Pull out your phone and just start recording them with video as well. It actually helps, okay, because they're on notice that you're recording them, and they can't object to it, and it's not a crime. They can simply stop talking, stop doing what they're doing, walk out of the room, whatever they want. So those are some tips and tricks in terms of using recordings in court. Best not to use video instead. Have any questions? Links in the bio. Stay safe.